Well, welcome everyone to our event, A Young Lawyer's Reading List. My name is Chloe Knox, and I'm the Vice President for Speakers for UVA's Federalist Society chapter. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. I'm delighted to introduce the moderator of today's event, Aditya Bomzai. Professor Bomzai's scholarship and teaching focuses on civil procedure, administrative law, federal courts, and national security and computer crime. He joined the UVA law faculty in 2016 and has had his scholarship published in various top law journals. Before entering academia, he served in the Office of Legal Counsel, as well as an appellate attorney in both private practice and the DOJ's National Security Division. He is a graduate of Chicago Law School, where he was editor-in-chief of the Law Review and went on to clerk for Judge Sutton on the Sixth Circuit and Justice Scalia on the Supreme Court. Professor Bomzai, thanks so much for moderating today. Before I hand it over to you, I'm going to remind the audience that throughout the conversation, you can submit questions for the judges at the bottom of your screen via the Q&A function. And at the end of the conversation, Professor Bomzai will return to ask those questions aloud. And with that, I'm going to go ahead and turn it over to Professor Bomzai to introduce our esteemed guests.
Well, thank you, Chloe, and thanks everybody for joining us. Good evening. I'm delighted to be here. My role is very brief and short. It is to introduce today's two panelists, Judges Justin Walker and Judge Benjamin Beaton, both of whom we're very delighted to host virtually, unfortunately, for today's discussion. Judge Justin Walker was confirmed to the United States Court of Appeals for the District of Columbia last year. He served as a judge in the United States District Court for the Western District of Kentucky before his appointment to the DC Circuit. And prior to entering the judiciary, Judge Walker was a law professor at the University of Louisville, where he wrote about, among other topics, administrative law, topic near and dear to my own heart. He's a graduate of Harvard Law School, where he served as a notes editor of the Harvard Law Review. He went on to clerk for then Judge Kavanaugh of the DC Circuit and Justice Anthony Kennedy of the Supreme Court. Welcome, Judge Walker. Judge Benjamin Beaton was confirmed to the United States District Court for the Western District of Kentucky also last year, to the seat that was previously held by Judge Walker. Before his appointment, Judge Beaton was the co-chair of an appellate and Supreme Court practice group at a law firm, and he's a graduate of Columbia Law School, where he served as an articles editor on the Law Review. He went on to clerk for Judge Ray Randolph of the DC Circuit and Justice Ruth Bader Ginsburg of the Supreme Court. Judge Beaton also serves as an adjunct law professor at the University of Louisville, where he teaches constitutional interpretation. So Judge Walker and Judge Beaton have graciously agreed to join us today to speak on the following topic: a young lawyer's reading list, great books and good legal writing. We're delighted to have them, and I'll certainly be taking notes on new material to put on my summer reading list. So Judge Walker, Judge Beaton, the floor is yours.
Thanks so much. Are we coming through okay on your end, Professor? Okay. Afternoon, everybody. Thanks so much for having us. When Rachel and Chloe first reached out about a talk, I had three goals. One, offer something different than your normal Zoom lecture fare. I know everyone is pretty zoomed out by now, so thank you for attending. Two, minimize my own prep time in deference to the litigants of the district courts, and to talk about something enjoyable and useful, hopefully useful anyway. So the idea that came to my mind was to have a conversation about books with my good friend, Justin Walker, which is something we do all the time anyway, and to invite you all into the conversation and get some reactions and hopefully we can all learn a little something. I want to offer three disclaimers at the start. One, we've never done this before. Two, we intentionally made no rules for how this talk would go, and we didn't share our lists with one another. And three, we make no promises that this format will succeed, but we're going to give it a shot. And I guess everyone gets what they pay for here. So with those big disclaimers, I'll say Justin and I have each selected a few items for a reading list that did or could have benefited younger versions of ourselves, and that we hope might help you all in some way as you all start your life in the law. So just to get us rolling, and to defer to my colleague in DC/Louisville, I'll just ask Judge Walker to set the ground rules and answer the big question. How did you pick the reading selections that you're going to discuss today and talk about with the good young lawyers to be in Charlottesville?
Thanks, Ben. First, I wanted to think of some different categories of readings. So I thought I'd do one kind of pure law reading, one history biography type reading, one fiction, and then one kind of wild card. And then for each of those categories, I had three factors. The first is I thought it should be something that there's at least a decent chance that the students have not already read in law school. So that hopefully excludes the Constitution, for example, Federalist Papers, a matter of interpretation, Morrison v. Olson, and go on and on, Citizens United. The second factor is it had to either change how I think or at least remind me of why I think what I think. And then the third and final factor is that it had to be beautifully written, at least in my opinion, have that kind of sparkle that that only writings from great writers have. So those were my three factors. Ben, you said we were trying to find things that would be beneficial to younger versions of ourselves, but we're two of the youngest federal judges in the country. So I think by some standards, at least, we are the younger versions of ourselves. But do you want to do your book first? Your first book first?
I'm willing if you like. My criteria were similar, if more random, perhaps. But I tried to identify selections that I remembered or that exemplify one particular lesson that I drew out and that I can hopefully leave with you all today. And so my first selection, certainly not to Justin's surprise, probably not to many people's surprise, is a Robert Caro selection. The lesson I drew from it is perspective matters in writing and in storytelling and in lawyering. This is the fourth of the LBJ biographies, Passage of Power. And it's important for two reasons to me. First, in one sense that has less to do with the writing itself, this book changed my life because it reopened my ears to great reading after they had been sort of plugged for many years, starting when I went to law school. And like many of you, I'm sure, I found that after a life full of reading, I simply didn't have time or the ability to hold my eyes open at the end of the day to read anything, much less lengthy books of the sort that Robert Caro writes. And it was, I don't know, 5 years out of law school or so when I came across an excerpt of this Caro book, the chapter about the Kennedy assassination. And started reading it, which is frankly an odd place to pick up the LBJ books, because in some ways that's the least new and appetizing part of what he has to offer in this, thousands of pages of LBJ's life, because it's the story that we're all the most familiar with. But I came across it in some publication, and I came across Audible, the audiobook app from Amazon around the same time, downloaded the book, realized that I could read / listen to great writing while I commuted, exercised, did chores around the house. And that reopened my mind to great books for the first time in years and years, and literally changed my life by reorienting my reader's appetite once again. And now, without ever cracking the pages of an actual book, I consume thousands and tens of thousands of great pages of writing every year. So I couldn't be a bigger advocate for audiobooks for the busy young lawyer.
What speed? What speed do you do audiobooks?
2.0 usually. Okay. 2.0 usually. I am aware of people who have gotten to 3.0, which they describe as time travel. I think that must have some sort of warping effect on the chemicals of your mind. I'll tell you, Justin, the other day I walked in on my son, who was listening to a Beverly Cleary audiobook in the morning while he was getting ready for school. And he had it on 2.0 speed. And I thought, oh, dear God, what have I done? I've created a monster. He's 7 years old, by the way. So he's now double timing it as well. But aside from that main point about just the importance, the opportunity to read however you can, I'll just underscore that, as I mentioned, the LBJ story of his time from majority leader to vice president to the early stage of his presidency is the most familiar. But one thing jumped out about it that makes it tremendous writing, even by the standards of the great Robert Caro, and that is perspective and how much perspective matters. We all know the story of the Dallas assassination of JFK, but normally that story is told from a clipped perspective. Kennedy obviously was only able, he told no one of what happened that day, and he was only there for part of it. Jackie was only there for part of the day and had limited insight. The folks on the grassy knoll had a limited perspective. Johnson, it turns out, had this wildly complete perspective on that day and an arc of a story that went from the lowest moment of his entire political career, when his aides were literally on the stand in DC, back in DC for corruption. The junior senator of Texas, who had been his acolyte, had just snubbed him. The Kennedys hated Johnson. That was the beginning of the morning. By the end of the day, he had seized power through wild events in a way more effective than any, probably than any American president ever has in that short of a time span. So it is very important for you as young advocates, counselors, litigators to focus on the perspective of the story you're telling. Spoiler alert, it's not yours that matters. It's the person you're trying to persuade, bring across to your side, recruit, lead. So that is what was so great about the this aspect of the Caro book. And I know we're trying to keep this to 5 minutes. Justin and I wanted to read just a smidge to give you all some color about what it is we're talking about. So I'll keep this excerpt quick, Justin, and then you can react and start with your first selection. So this is just a couple of paragraphs from the beginning of the book. trailing them in the rented car, driving between crowds of people cheering, but not for him, sharing a seat with a man who had humiliated him. Lyndon Johnson was far enough behind the presidential limousine that the cheering for the Kennedys and the Connollys, for John Connally, some of it, for his one-time assistant, who had become his rival in Texas, had died down by the time his car passed, and most of the faces in the crowd were still turned to follow the presidential car as it drove away from them. So that, as Lyndon Johnson's car made its slow way down the canyon, what lay ahead of him in that motorcade could, in a way, have been seen by someone observing his life as a foretaste of what might lie ahead of him if he remained as vice president. 5 years of trailing behind another man, humiliated, almost ignored, most important, powerless. The vice presidency, filled with trips, chauffeurs, men saluting, people clapping. In the end, it is nothing, as he later put it. He had traded in the power of the Senate Majority Leader, the most powerful majority leader in history, for the limbo of the vice presidency. Whatever happened to Lyndon Johnson? A mocking headline in the Reporter had asked, because he had felt that at the end might be the presidency. Now there was another man who might want the presidency, the younger brother, Robert F. Kennedy, UVA grad, the Attorney General, whose dislike and contempt, hatred is not too strong a term, for him was well known in Washington. And in 5 years, Bobby Kennedy would have had time to build up a record to hold other positions besides Attorney General. So I'll stop there. That is a taste of the famous Caro prose style, and one that has a pace and a color and a voice unlike perhaps any other nonfiction writer in his generation in America.
Then I was going to ask you what Caro does well, but I'm not going to ask you now because the excerpt shows it, or at least shows a lot of it. Frankly, I had not forgotten how thorough the research about. Is me there?
Yeah, I couldn't hear you for just a second. It might have been on my.
I had not forgotten how great Caro's research was, but I had forgotten how good the prose was. And one of the reasons it's easy to forget is because it takes that guy about 500 years to write every book. So it's been forever since the last one, and we're all kind of, pulling for him to finish the fifth and final volume.
Him and George R.R. Martin are the two octogenarians.
Yes.
We need to just write already.
So I'm going to start with an excerpt from my first book, and I'm going to do this for each of my books, and I have 4 if we have time for them. So we'll start with an excerpt for each of them, but this one is the only one I'm going to do this. If anybody recognizes this excerpt, send a chat, a post, however the Zoom thing works, to Chloe, or to Aditya, it's pretty obscure, and I will say this. I don't presume that anyone listening is interested in clerking. And by the time Ben and I are finished, at least in my case, you'll probably be a lot less interested in clerking for me after having had to listen to me for an hour. But if anybody recognizes this and is the first to get it right and send it to Chloe, I'll give you a clerkship interview. So here goes.
Does that apply to me too?
We've been on the same court before. I know from experience you don't have any interest in spending any more time on the same court as me than you already have. I've already been subjected to this. Ben has a pending 1983 cruel and unusual punishment claim against having to work with me. So here's the quote. I wanted my wife to realize clearly one long-term penalty for herself and for the children of the step I was taking. I said, quote, "You know we are leaving the winning world for the losing world. I meant that in the revolutionary conflict of the 20th century, I knowingly chose the side of probable defeat. Almost nothing that I have observed or that has happened to me since has made me think that I was wrong. Somebody got it. Somebody nailed it. Cannon Mills. Can't wait to meet you, Cannon. This is fantastic. I'm going to finish the quote, but you've made my day. Hell, my month. That's fantastic. Terrific. All right, I'm going to finish the quote. You know, we are leaving the winning world for the losing world. I meant that in the revolutionary conflict of the 20th century, I knowingly chose the side of probable defeat. Almost nothing that I have observed or that has happened to me since has made me think that I was wrong about that forecast. But nothing has changed my determination to act as if I were wrong, if only because in the last instance, men must act on what they believe right, not on what they believe probable. So Cannon nailed it right away, and Professor Bomzai also knows that immediately follows the introduction, which Whittaker Chambers calls a letter to my children. So I'm going to ignore the chat function at this point. I don't know how to turn that off, but I think I can. So here's the book.
Chris Baldacci also got it.
What'd you say?
Chris Baldacci also got it.
Well done, Chris. Well done. But first, I think I said first. Book is called Witness. It's by Whittaker Chambers. Came out in 1952. And as Professor Bomzai's quote that he had in the chat mentions, the introduction to the book is a 25-page letter to my children. And in it, he says, for the rest of your lives, for better or worse, and very likely for worse, you will be associated with my testimony against Alger Hiss. Whittaker Chambers was a former communist. Alger Hiss was a communist spy. He was former Supreme Court law clerk. Alger Hiss was. He was with FDR at Yalta. And he was a big deal at the time. And here's this kind of nobody Whittaker Chambers, kind of frumpily dressed. I don't know if that's the right word or not, but not very polished, and he accuses this kind of darling of the East Coast intelligentsia of being a communist spy. Of course, we now know that he was telling the truth. It was clear he was telling the truth at the time. After the fall of the Soviet Union, the records from Moscow confirmed what was obvious, that Alger Hiss had been a spy. So he says to his children, you'll always be associated with my testimony. And he says, I'm writing you this book and this letter so that you know not what I was a witness against. I was a witness against communism. I was a witness against Alger Hiss. So he says a man is not primarily a witness against something, but rather for something. That's what matters. And he wants his children to know what he was a witness for. And I encourage you all to read the book to find out and to make up your own mind what you think he was a witness for. I have my theory, and he certainly hints strongly at it. He says to his children that back when they were younger, they would walk through the pine woods together and they would reach for his hand when it got dark. And he says that it will often be dark. And he says, this book, this letter is my hand. And if I lead you the right way, you'll end up at a hill, and on that hill will be 3 crosses. So it's a powerful witness, in my opinion, and it challenges, I think, the reader. At least it's challenged me to think about what I'm a witness for, not just in terms of what I believe, but in how I mesh what I believe with how I live. And he did that very well, and he wrote about it in as eloquently a way as any autobiographer that I've ever read.
My only reaction to that, I suppose, and this is my personal take, boy, it's a pretty dark read, huh? You spend a lot of time in the mind of a man who, for good reason, is in a depressing place. And
it's a dark world, Ben. You know, the fall and all that.
Right. But, you got the fall, and then you have those crosses, right? So anyway, different. Yeah, it comes back to perspective, I suppose. As,
well done, well done. This is all it's like the rug in the Big Lebowski that ties the room together.
The web in Robert Penn Warren, another example, I believe. It's been a while, but I think that would fit. Okay, my next selection is another one that won't be a surprise. Maybe I'll go off the beaten path next round. But my next selection is the Scalia Speaks compilation of Justice Scalia, many of Justice Scalia's many speeches. I can avow that I picked this before I knew Professor Bomzai would be our moderator today. This is not an effort to kiss up in any respect. I just think this is the most rapid and engaging and wide-ranging way to engage the most engaging, insightful, and wide-ranging legal writer of the last 50 years, or perhaps further. So we don't need to belabor the attributes of Justice Scalia. He's the reason I went to law school, and probably many on this call can say the same. The reason why I picked this instead of one of those more familiar texts, perhaps, that Justin mentioned earlier, is for the additional breadth and casualness, perhaps, of getting Justice Scalia and his speeches. It covers such a wide range of topics: education, family, friends, faith, of course, the law. That it is the rebuttal to George Will's frequent quotation that law school often sharpens the mind by narrowing it. I can't think of a better rejoinder than reading Justice Scalia on these many topics. Here you see this, the legal icon sort of tilling many fields alongside the law. And you realize how the sort of breadth of his thinking and reading affected and undoubtedly improved his ability to reason about and explain the law. The one selection I'm gonna pick, I was a little torn. There's one that is truly close to my heart, from the faith section, called "The Christian as Cretan." And for those of you who are drawn to this subject, I would definitely commend it to your attention. But I am going to stay a little more sort of on topic in terms of the development of young lawyers by choosing the selection on legalese, legal canards, there's something also to the notion that the spoken word, and again, these are all speeches, can help us as lawyers and judges and professors in many ways fight against the sort of rhetorical walls that the law and our profession often puts up between not just real people, but also lawyers and other actors in the legal system, and the ideas that words often will obscure rather than illuminate because of the way we use them. This is a topic near and dear to my heart in my current duty station, as I adapt all sorts of orders and templates for the work of the busy work of a trial court. And I asked my clerks about one order we found that contained just a absolutely mind-blowing, I guess you'd call it a paragraph.
Was it written by
Uh,
your predecessor?
One of my predecessors on my multi-member court. It was not written by anyone on this Zoom call. I'll say that much. So here's an example of some of what that which Justin and I have to deal with, and that we I think would enlist your help in fighting against throughout your career. This sort of legalese that innervates the law. This was written by a federal judge, or at least signed by a federal judge. That said motion be, and the same is hereby, all caps, sustained, and the filing of said third-party complaint is hereby noted. The clerk is hereby directed to issue summons on said third-party complaint for service on the third-party defendant, unknown defendant, period. Now, if you can tell me what that means, then you should, I guess, skip right out of law school, become a judge right away, because I cannot make heads or tails of it. One of my law clerks remarked that it was practically a foreign language, which of course is how law school sounds to most of us when we begin. It shouldn't sound that way when it ends, but that is an example of what you may have to fight against. And so Justice Scalia, as is so often the case, has a comment on this. This is the beginning of a talk he gave to the Case Western Law School called Legal Canards. Every judge, and indeed perhaps every lawyer, acquires over the years an intense dislike for certain oft-repeated statements that he is condemned to read again and again in the reported cases. It gets to be a kind of Chinese water torture, one's intelligence strapped down helplessly by the bonds of stare decisis that require these cases to be read and trickled upon time after time by certain ritual errors, vapidities, and non sequiturs. It is usually impossible to cry out, even in a dissent, for these statements typically have little actual impact upon the decision of the case. They are part of its atmospherics or of its overarching philosophy. It is fruitless to complain about the weather and unlawyerlike to discuss philosophy rather than the holdings of the cases. So, and then he proceeds to discuss a few canards. Remedial statutes are to be liberally construed. A foolish consistency is the hobgoblin of little minds. The familiar parade of horribles. So obviously the strain of legalese he was complaining about was slightly different than what you heard in the order that we found, but it is certainly of the same genus, I would say. So, Justin, you didn't stick around too long on the district court, and you read a different type of work product nowadays. But did you take any steps, or do you take any steps to address what I view as the scourge of legalese in our profession?
Oh, I suppose so. I certainly share your contempt for it. I would point out that I think of the two of us, you have a reputation for kind of diplomacy more than I do, and yet I'm not the one who just held up one of my colleagues' orders for ridicule. So. I feel like we're more kindred spirits than maybe you have been willing to admit in the past. I would actually point out from the Scalia Speaks book, the thing that struck me the most is not that how brilliant he was, which he was, or what a beautiful writer he was, which he was, or what a history maker he was. That was already kind of foremost in my mind when I went into reading Scalia Speaks. But what I hadn't really appreciated before is what a product he was of the Warren Court. And I mean a product of the Warren Court in that he was the backlash to it. And I think his strong disagreement with the what he would call the lawless activism of that court informed so much of his jurisprudence, are arguably in a way that, well, I think there is now a trend among judges who are very sympathetic with the Federalist Society to not be as skeptical of judges and judging, not as he was at times. So one example is he was certainly a frequent advocate for Chevron deference. And I think part of the appeal of Chevron deference was it tied judges' hands. And in the wake of the Warren Court, Justice Scalia was very skeptical of what mischief judges would do if their hands were not tied. I think now there's a reappraisal of Chevron, and there are scholars out there who, including possibly our host today, our MC, who say, it might at times be beneficial to tie judges' hands, and certainly nobody wants judges to be activists. But if tying judges' hands means letting unaccountable agencies run free, it may be that you've found a cure that's as bad as the disease. I think that Scalia's aversion to the Warren Court activism, his understandable aversion to the Warren Court activism, left him at times not as tuned to this growing concern. What do you think?
I make two. I think that's a great point. Two quick responses before you go next. One, I would say you can harmonize. I think your explanation is causally correct in terms of the Warren Court, but not necessarily a complete account. Perhaps a more complete account of the way his philosophy would interact today is he would be an opponent of unaccountable power, period, or uncabined power, period, regardless of whose hands that power resided in. You can see the about face on our deference as an example of that. That certainly was an aversion to uncabined power. And historically speaking, that's a great point that I hadn't thought about before. And what came to mind was a sort of sliding doors moment when, what if, the Goldberg pick doesn't happen? What if, Jackson and Frankfurter and, live longer? John Marshall Harlan has a more leadership role on the court, and you have a sort of a less aggressive, more common law mode of constitutional adjudication during the 50s, 60s, 70s. Does originalism and textualism look like it does today? I think it's a really interesting sort of counterfactual.
I'm actually going to do my next two, and I'll try to do them fast, and we may save some time in that, and then send it back to you. So I'm going in chronological order here. This is from 1960. The lead character in this play, his daughter says, "But in reason, haven't you done as much as God can reasonably want?" And then he replies, "Well, finally, it isn't a matter of reason. Finally, it's a matter of love." So that's from my favorite play of all time, Robert Bolt's A Man for All Seasons. Those tabs are from high school, but that's not when I read it. My mom gave it to me before then when I was a kid for Christmas one year. And I love the movie. I've seen it on Broadway. I love the stage version. And I love the play on the page. Moore's story doesn't need to be summarized. It's so well known. It's at this point almost a cliche. But there's nothing cliched about the writing by Robert Bolt, who also wrote my favorite movie, or one of my 2 or 3 favorite movies, Lawrence of Arabia. And it was almost about a year ago today. It was Good Friday. I got a temporary restraining order at 6 o'clock at night about the mayor's attempt to prevent a church from gathering on Easter. And A Man for All Season was one of the first things I thought about. That line is one of the first things I thought about. It occurred to me, obviously, these congregants had a right to pray together on Easter. And I knew why they wanted to, but I knew that it would be impossible to explain why they wanted to, because their reason didn't have anything to do with logic, or it had everything to do with love. And so I wrote the last line of that temporary restraining order first, and the last line was the quote that I just read to you. Finally, it is a matter of reason. Finally, it's a matter of love. The other book is going to fast forward to 2012.
Hey, Justin, while you're opening it, can I just make one comment to further stitch together our rug or web or whatever we're going to call it? The Christian as Cretan speech that I name checked in the Scalia Speaks book talks about that very play. Well done. I promise we didn't know what
we didn't have planned this at all. We didn't plan this at all. So here's this quote from 2012. This is the pure law category. Just a hardcore academic writing hardcore scholarship. He quotes Madison's writing the Federalist paper about how different governments will control each other. And then he says, Madison's assertion that the levels of government will invariably control each other seems manifestly in error. Very often they cooperate for mutual benefit and aggrandizement. I read this fairly recently, even though it's not especially new. It's called The Upside Down Constitution. It's by Michael Greve. It's a professor at George Mason Law School. And it's one of those books that, you think you know something. You think you know a little bit about federalism. And then you read this book, and I came away thinking that a lot of what I thought I knew I was wrong. His theory, which deserves more than 30 seconds, but I'll try to kind of sum it up in 30 seconds, is that the Constitution imagined states competing with each other. And that was a great idea. What we have now are states that don't so much compete with each other as they form a cartel, a rent-seeking cartel. And an example of this probably is more helpful than speaking in the abstract. Imagine that imagine there's a special interest group in Kentucky that wants to raise taxes because it's good for them. They're not the ones who are going to be taxed. But the problem is, if you raise taxes, the people who get taxed will leave the state, at least some of them. And so we end up raising less revenue than you would before you did the tax increase, maybe. Well, what's the solution? One solution is if you can get Congress to raise the tax and then send the money back to the states, now your taxpayers who would have left had it been a state tax that was raised, they don't have anywhere to go. Whatever state they go to, they still got to pay the same tax. The state gets just as much money, but it doesn't run the risk of these people leaving. One more example: imagine a state wants to do a very burdensome regulation with a very small benefit to a very small interest group. Well, they might not pass the regulation because, again, they don't want the regulated entity to leave the state or to leave the state. But what if they can get Congress to pass it? And that way they get the same regulation they wanted, but nobody can leave the state because they leave the state, they're still going to be subject to regulation. So that's what Greve calls cooperative federalism or cartel federalism. And he makes a strong argument that this amassing of power in DC did not happen kind of over the objection of states. It happened in many instances because it was in the interests of states, or at least in the interests of special interests in states, to cede that power from the state to DC. And it allows the state, whether it's they want to raise taxes or whether it is they want to do a heavy regulation where the benefits are far outweighed by the costs, it allows the state to kind of have its cake and eat it too. One of my favorite lines from the book is Greve says, this is a very long book, but that's because we have forgotten so very much, or something along the lines there. So highly recommend it for anybody interested in federalism and anybody who is as silly as I was to think that I kind of understood federalism. Just shows that no matter what the topic is, that there's always a lot more to learn. It was a humbling read.
Is that critique different, or is that accounting of federalism different than, say, what any fan of Hamilton the musical, as you and I are, would remember as the infamous dinner between Madison, Jefferson, and Hamilton, in which some states captured, so to speak, the location of the Capitol, and other states foisted off their debts on the national government?
I don't know. In some ways that strikes me as kind of what do you call it? Two people bargaining who have, or two states bargaining with each other that have that similar leverage. This, to me, the parallel here is, and we see this all the time. When look, everybody watching this is going to be the member of a bar one day. Well, the bar is a cartel. It's rent seeking at its finest. You have a bunch of lawyers, and they don't want to have to compete with people who aren't lawyers, so they get the state to require, they get the state to prohibit clients from hiring anybody who isn't a member of the bar. It's the same concept that you have with, you have to get a license to be a florist in some states. You have to give the license to be a shampooist in some states. Why is that?
Or a doctor. My goodness.
Well, I mean, look, I'm not saying you and I are going to agree. I know that, from the perspective of, an anti-libertarian like you, Ben, that you probably think it's appropriate that in order to do interior decorating, you have to get a license because, you can't trust the market to weed out the bad interior decorators. But from my perspective, there's a lot of rent seeking that goes on in the country. And I had a case on the district court that I wrote an opinion that suggested that the alleged state interest in the regulatory scheme was somewhat suspect, and that what may have been going on there was nothing more than rent seeking, a special interest group that was seeking to create a monopoly through legislation.
Well, I'll leave your anti-libertarian comments to the side, noting only that guilds and the bar predate the Constitution rather. My next selection is totally off the beaten path. The lesson I want folks to take from it could be phrased in many different ways, but I'll keep it short and sweet with write good emails. We can't consume good writing all the time. No one has the time to ingest all the information we need by reading Robert Caro, 1,200 pages on Robert Moses. We all know that it is important to maintain discriminating taste in our consumption of words. Yet, what about all the words we read not for pleasure, not for advocacy, but because we actually need to get the information? You will have occasion, because your career will require you to learn new areas of the world. It's one of the beauties, frankly, of being a litigator. If you go in that route, you get to become a short-term subject matter expert in all sorts of aspects of the world. If you're a curious person, and you probably are, if you're thinking about being a litigator, then you're on the right track. You can acquire information from a lot of really bad writers, a lot of really verbose writers, people with their nose in the air, with terrible judgment. But there are some really good ones too, and they don't, again, have to come from the hoity-toity section of your campus bookstore. Back in the day, I used to be, believe it or not, a pretty decent SEC regulatory lawyer focusing on, of all things, market structure regulation in the capital markets from right here in the turquoise dungeon, as we call it, in Louisville, Kentucky. Not the normal habit of a Wall Street regulatory lawyer, but I was able to pull it off for a time. I had a ton to learn because my background's not in finance, wasn't a banker. I don't have education in that area, and some of the stuff is really complicated. And so in those circumstances, it is important to find folks who can teach you in a hurry, in a way that is not sort of soul crushing and mind numbing. So I came across this guy who writes a column every day, and a digest really, called Money Stuff. And he's an opinion writer for Bloomberg, which is a client of mine, but that's not why I'm calling him out. But he has just the most delightful, irreverent, crisp, hilarious, thoughtful voice that teaches you while reminding you that you can write concisely, but really well, which is something you guys are going to be doing a lot. You're not going to start off unnecessarily by writing big Supreme Court briefs or truly meaty opinions. You're going to be sending a ton of emails and writing a bunch of comment bubbles, and every word's going to matter in those. People are going to need information from you, and they're going to be assessing your judgment. So here is the beginning of a Money Stuff email from last month that talks about a big case in which Citigroup lost $900 million. So there's a legal hook here too. So here you go. Last August, Citigroup Inc. wired $900 million to some hedge funds by accident. Then it sent a note to the hedge fund saying, oops, sorry about that. Please send us the money back. Some did. Others preferred to keep the money. Citi sued them. Yesterday, Citi lost, and they got to keep the money. I read the opinion by U.S. District Judge Jesse Furman, expecting to learn about the New York legal doctrine of finders keepers. More technically, the discharge for value defense. And I was not disappointed. But I was also treated to a gothic horror story about software design. I had nightmares all night about checking the wrong boxes on the computer. The story is that in 2016, Revlon Inc. took out a 7-year syndicated term loan. Citibank is the administrative agent on the loan. It gets interest and principal payments from Revlon and passes them on to the lenders. Revlon ran into a bit of trouble and, as companies do these days, it did some creative stuff with its debt. In May 2020, it convinced some of the term loan lenders to strip collateral from the term loan so it could be used to back new debt. The lenders who were part of this incredibly aggressive deal got to roll over into the new, effectively more senior debt. The others were left with worse debt and got mad. Some of them got together to work on a lawsuit, which they filed. 20 hours before they filed, though, they got lucky. Citigroup just wired them all their money. They received wire transfers for the full amount of principal and accrued interest they were owed on the loan. Their first reaction was mostly, well, this is weird. I guess Revlon decided to pay off the loan rather than fight about it. Their second reaction, after Citi sent them frantic notices saying it was a mistake, was to send each other Bloomberg chat messages making fun of Citi. Their third reaction, after some more serious reflection, was to say, we are keeping the money. See you in court. All of these reactions were pretty reasonable and worked out well for them. So this is an incredibly complex case, the likes of which many of you will probably work on one day. It would consume 20 pages in an appellate brief or even a district court brief, just explaining the facts. And here's a guy who can distill it down to its essence in short, clipped, irreverent, memorable sentences that give you exactly what you need to know, not one word more. And I would encourage you all to seek out not just, again, the big weighty books that can teach you about reading and writing, but even especially in the consumption of the material you're going to need on a day-to-day basis, look a little bit harder for the really good writers and thinkers who can convey that. They're out there.
I'm going to read Money. Wait, I wrote it down.
Money Stuff.
Money Stuff. Money Stuff. And I think I'm going to enjoy it. So I'm happy to give that tip. Why don't we spend 30 seconds each on our fourth book, and then open it up to questions. I'll just very quickly say that my last selection was recently in the Harvard Law Review by my predecessor, Judge Tom Griffith. And it's an essay about civic charity. And what that translates to is a cri de coeur by one of the most decent men I know. And he's pleading with our country to beware of tribalism, to disagree with your opponents without hating them, to engage with them based on their ideas without questioning their motives. And, you know, he takes inspiration from the Constitutional Convention, from Lincoln, from Robert Kennedy. And it's a message that I think we need now more than ever.
Well said. My last selection was going in a different direction. It was hardcore legal writing, but in the judicial sense. The lesson would be, if you're learning to play the game, don't just watch the highlights, watch the whole game. I'm aware of one particular distinguished jurist, well known to Justin and to Professor Bomzai and others here, who encourages folks to read everything that the Supreme Court writes. I think that is a great way to learn a lot about federal law, but I respectfully dissent from the view that that's a great way to learn legal writing, precisely because what the Supreme Court does is so different from what the rest of us do most of the time at the bench and bar. It's certainly different from what I do in the trenches of the district courts. It's even different than what Judge Walker gets to do in the DC Circuit. I say this because the Supreme Court's docket is so curated. Its decisions are so divorced from facts, you know, by design. It does not have to worry about further review, and it knows exactly sort of who the audience is and who will be on the other side, unlike basically everyone else who practices law, worried about factual disputes, dealing with inconvenient precedents head on, parsing really messy briefs. And yet, despite all that, you still have some fabulous writers who can display for you a level of legal writing and argumentation that I think will be more instructive than Supreme Court decisions for what most of you will start off doing. I was going to give as an example of one judge whose writing you could just consume. You know, one strategy here, I guess, to say is you could pick a court, as I did for a while when I was blogging on the Sixth Circuit. You could pick a judge whose work you really respect, whose writing you have your ears attuned to, and just read what that judge produces on a regular basis. And you won't be reading just what shows up in How Appealing and Law 360. You'll be seeing how they deal with sort of day-to-day argumentation. That's a really valuable skill. And so the great writer and good friend of mine from the DC Circuit, whose work I was going to call out, is not named Justin Walker, is actually named Ray Randolph. And to this day, he and Frank Easterbrook, another absolutely fantastic writer, will swap all their opinions. And I think it's so glorious that after 50 years at the highest levels of law, they're still reading each other's drafts, you know, opinions, sending notes. And for anyone who really wants to get a great deep sense of the outputs of the federal courts in a way that teaches you about the law, but also about writing, I think that's a really effective strategy that all of us should consider.
Completely agree. Should we do questions? Do we have time for questions? I don't know. Are we going till 6 or 6:15?
Judge Walker, I believe we do. If we go till 6:15, that's when we can cut things off. And
that's great by me.
There are a few questions in the Q&A, and so I think I'll just launch right into it. First of all, thanks for the very stimulating discussion. I was taking notes, as I mentioned at the beginning.
We want your list. Can we get your list?
You can. I actually went to my bookshelf and was reminiscing about when I read this book, War and Peace by Tolstoy, during the year that I was clerking. This is the book that I was reading I guess my list is in my spare time, I like to read non-legal things, just things that are different. And Tolstoy, one of my favorites. So that year when I was clerking, I was reminiscing, thinking about this because sometimes students will ask me, I'm going to be done with law school. What should I read this summer as I'm studying for the bar or in my spare time over the next year? And maybe this is just me being parochial. This is what I read when I was done with law school. I read War and Peace and Anna Karenina. And just a couple of days ago, I read the death of Ivan Ilyich again after I think about 25 years. So I recommend those to you if people are listening. I also like to read like ancient history. So I remember I read Donald Kagan's History of the Peloponnesian War that year. And you may look at the size of War and Peace and think that's a really challenging book, but actually it's just not challenging. It's a story. It's it's as easy to follow as like a simple soap opera might be. It's all about personalities and human beings. So those are my recommendations. Well, let me launch into the questions because we do have some, and I want to make sure that we answer them. The judges have a chance to speak to these points. So a couple of questions I'm going to combine. Some folks in the Q&A have asked, what do you think you can learn from the writing styles of Supreme Court justices? And if you have examples. And then this is the second question, which I will combine with the first. What do you think about judges using pop culture references? Does that work, or is that too cringe? What's your advice? How do you strike the right balance about writing informally versus connecting with the audience? So over to you all.
I think I already gave my 2 cents about learning from the writing of the Supreme Court justices. So, Justin, you can respond to that question or to anything I said that you disagree with.
I said I agree with you, Ben. There are some great writers in the Supreme Court. I'm not going to name names because then that could be offensive to names that don't get named. I think Ben's suggestion of picking a judge and just reading everything that judge churns out, I think is a great suggestion. I hadn't thought of it before. I guess the only thing I would disagree with Ben is I do think you could probably do that with a Supreme Court justice just as well as you could with a judge. But I agree with Ben. I think it makes more sense to do it with a judge or a judge/justice or a handful of judges/justices as opposed to doing it court by court. On pop culture, you want to take that one first, Ben?
I don't have super strong views. I mean, I think it's, I'll take the question up one level of abstraction. Like, how formal or informal should legal writing be, in particular judicial writing, which, in some instances establishes a sort of law, and in other senses, decides real world consequences, often of high stakes for people. The standard I would hold up is your writing illuminating the law, or is it obscuring? To use a sort of a juxtaposition that I mentioned earlier. There is no doubt that it is fun and enjoyable for lawyers to read interesting legal writing. Often that means allusions that are clever, that are witty. Sometimes I think it's fair to say they can be overdone, and you can go so far from the sort of legalese end of the pole that legalese pole end of the spectrum that I mentioned earlier in that silly order, to something that is so sing-songy that it can become hammy, and it can call into question whether this judge is saying what he or she wants, or actually is someone sort of constrained by the law to say what the law is and how it decides the case. So often there's no doubt. I mean, I called out Scalia earlier, right? Here's a writer who, more than anyone else, I think, was able to bend sort of allusions to his point, and he used them in a way that made the law clearer. Most of us don't have Justice Scalia's pen, and some of us try really hard, and some of us fail. So that's the way I would approach it, I guess. It can certainly be overdone, but there's nothing wrong with it in principle if it clarifies the point.
So I mentioned earlier that I ended an opinion with a quote from A Man for All Seasons. So you know that I'm not completely opposed to making pop culture references, although you can decide for yourselves. I was just going to say it's 60-year-old play, so maybe it doesn't count as pop culture. I mean, I'm constrained in being able to make pop culture references by my just general lack of knowledge about pop culture. So if we're talking like 80s movies, then I'm on pretty solid ground. But if we're talking like popular music, I'm not going to be able to do that, even if I wanted to. I think my answer to the question is that you should never make a pop culture reference in an attempt to kind of play to the crowd or get a tweet on Twitter. And one way that I try to guard against that is during two confirmation processes, which is kind of two more than anyway, confirmation processes are unpleasant. I had to read news about myself, and after I got confirmed to this job, I just made a decision I'm not going to read any news about any opinion that I write. And that includes Twitter, that's social media, whatever it is, New York Times. And so, I think if a judge is out there trying to make a pop culture reference so that the opinion gets more attention, then that's not a good thing to do. If you're making pop culture reference because you think it, as Ben said, illuminates the legal point that you're making, or makes it more accessible, or makes it more clear, or makes it more powerful, then I think the occasional pop culture reference can be a good tool, and I do it.
So I'm going to ask two more questions that are in the Q&A. They're a little bit different from one another. So maybe one judge will want to take one and one the other, because I think we're going to stop at 6:15. So there's a question here about whether you have any other recommendations beyond immersing yourself in good writing to developing the habits that produce the kind of excellent prose that you've been citing through this talk. So that's the first question. And then the second question is actually more of a question about judicial philosophy. And so it's a question that is being asked by a first-year law student at the law school. And the question is whether is law school a moment when you're supposed to develop a unifying theory as to your judicial philosophy, or is some inconsistency okay? Did you find in your own classes that you were sympathetic to some justices in some classes, and then other justices, say, in your criminal procedure class, using that just as an example? So those are the two questions that I wanted to kind of throw over to you, and then I suppose you all can close in whatever way you think is best. And it's been a great talk.
Ben, how about I take the last question first, and then you can take them both, or the first one, or whichever you want. There's this story, undoubtedly apocryphal, of a guy who says, in response to the question, what do you do? He says, I'm a student and a traveler. And the person who asked the question says in response, aren't we all? For the person who asked the question, are you supposed to leave law school with a grand unified theory that I guess presumably would be fixed in stone and you've got it all figured out? I don't think anybody has it all figured out. The best I can hope for is to learn a little bit more tomorrow than I did today, and then do that again and again and again, so that over time, whatever views I have are more informed and better over time. So that's my answer to that.
Yeah, I agree. I'll answer it a little bit differently, and it's a topic that's on my mind as I've started hiring law clerks. As everyone here knows, that's happening increasingly early once again, and in an increasingly homogenous way, or with sort of less heterogeneity among perceived ideological sorting. I would say that an unfelicitous turn of phrase, but one that I think your experience bears out. I'm concerned that as a result of that, law students are coming to their their positions in the great sorting of America very rapidly, and in a way that can't possibly happen too naturally over time with the guidance of people who actually can, who are skilled in teaching you how to think, like Professor Bomsai, as opposed to not just absorbing what to think. That's a real danger, and it's a danger for those of us who think that the law is different than politics and is a profession that will point in different directions on different questions. So I would be nervous if people were finding themselves agreeing over and over again in all their classes and what they perceive as a 1L or a 2L as the sort of correct direction. On the first point, I would just say this is not a particularly sexy answer, but I think it's very important to read, in addition to some great literature, but other stuff that is about how to write. That's very much sort of a professional tool. Brian Garner is the first name that comes to mind. If you read one of the usage books, the big heavy one up here, you're going to learn a lot about words, and a lot of that's going to sound like fingernails on chalkboards when you read how other people write, and when you hear other people speak. Things that never bothered you before will. But that's a process of becoming, learned in the law and in the craft. And you'll undoubtedly be better if you're, in addition to exposing your ears and eyes to this highfalutin stuff, if you're also focusing on a macro level, like what is just the right word to use in this situation. And before I just, type it out, let me look at this usage guide. Let's see how Garner put it. So it takes time, it's hard, but so is a lot about the law, and it's worth it in the end, in my view.
I just jump in to say thank you to the students who are on the Zoom call. Thank you to Chloe and the Federalist Society for the invitation. A big thank you to Professor Bomsai for being a great host, and for the great Tolstoy and Donald Kagan recommendations. And then I'm looking, and thank you to Ben for putting up with me as he has for the past decade. And then I'm looking forward to being Kanan Mills and Chris Baldacci. So that'll be a treat for me.